Wait, please do my lords. Sir, I can 8.
Yes.
Well, it's.
This is an SL which is.
May I, with your lordship permission, I can 8.
They're already quite.
Well, I just give 3 or 4 minutes, whether I want to make your lordship heard us in the other round, in the other combination. What I was saying was, well, we are people who are offered other options. We are only a finite 2,800 persons in Chhattisgarh. All other states actually gave the appointment letter in time. All processes were done before your lordship's cut-off date, but the actual appointment letter formally came afterwards. So it's something beyond my control, beyond my fault. There was a delay by Chhattisgarh. I got the letter 2 days later.
Let us not start from the beginning, but let us start from the beginning. This is an SLP report. This is an SLP against the judgment of the Chhattisgarh High Court,
Wow.
where the Chhattisgarh High Court has not protected our appointments which have been made.
Which we are protected in
In all the other cases, your lordships, Chhattisgarh has not protected because
see what happens will be protected.
we are the real.
So that there is no confusion. What I do is, if you can 5 minutes, you can tell my brother about it because combination is slightly new.
Correct.
I want to hear it because other day you were making a submission that some important points have not been done, or something like that. But you did something that you are not. What you also said, you will do that today. But you tell something. This is a different combination.
All that you have to believe this. Yeah.
So, Millards, I have the permission to the court survive. Since I argued the national alert in the High Court, the High Court, let me. Alert, the Ramesh Sharma judgment is.
Before all of this start, let us be very clear. We had held in the judgment that diploma and not B.Ed is the qualification. That's number one. Secondly, when you file the review petitions and all that, we had clarified when Justice Anirudh Bose and myself were there that where selection as well as appointments have already taken place prior to the date of the judgment, which is the date of the judgment.
August 20.
11th August.
11th August
2023.
And these appointments are 29th September 2020.
Now, and then we made it very clear in paragraph after paragraph. This is the controversy which keeps on coming like this.
Several.
That selection and appointment. This is selection will not do. Appointment. So if you are not covered with that subsequent clarification, if you are you have to get benefit by that clarification, of course we'll give it to you. No doubt. Because subsequently another application was filed
I am here.
So we are dismissed that.
No, not to discuss it, saying that litigation has to be by those very people, not with you.
Whatever we discussed. Now, is that the case with you or there is some new case?
There is some problem.
One opinion is after 11/8/2023 that case.
As it is respect of Chhattisgarh is concerned, the present situation is not, it's covered by the particular judgment, where you have clarified it. But we are seeking something more, because Chhattisgarh was not party, what transpired there, how it is not applicable, what has given the attention of this court in the previous judgment, that's all we can point out in this case.
Chhattisgarh.
Chhattisgarh,
We are only concerned with Chhattisgarh.
no,
Any other person apart from Chhattisgarh?
I don't think that is right. This is clarity from council offices.
So let us get Chhattisgarh there.
Yes.
My lords, I will just add.
I wish to be.
That when my lords issued the clarification on 8th of April 2023, Secretary Justice Anand Court, putting this cut-off date at 11, and also adding one more proposition that if the appointments were conditional, subject to any orders, we will out there, and my lords,
She wants to clear
the
this.
orders will apply across all the states
Yes.
and is not going to be confined just to that particular batch of matters. My lords have already made that up.
इतनी short memory थोड़ी है ना.
I just say,
What we are
Let-
saying, because you are very many other states who had filed intervention and who were present there.
correct.
Here is a case where Chhattisgarh has made its own rules. It is the rules which have been not struck down because of a lordship judgment. We are trying to show that that rules could not have been struck down, and therefore, this is why it has to be heard, not inside effectful submission.
Why?
No, because I have shown that.
Because there is something called an implied striking down also.
No, so not, what your lordships have said in the last para of the Devesh Sharma, is there that if there is a statute otherwise, then you are not, it need not follow. Therefore, I am saying that the last para of Devesh Sharma makes it clear, this is what I submitted last time, and your lordship then July, saying that will hear you on.
Yeah, that day actually what had happened was
The lot of people were trying to make.
what we were very virtually and we were not there to set up things with him.
What I would respectfully submit with us is, Chhattisgarh is a standalone case, it stands on its own, very peculiar and distinct facts.
Yeah, tell us that.
Lord says. Now, in case your lordship will just add the small notes, and if this goes on.
Perhaps one suggestion which I could make, if your lordship so desires that my law can also be updated, We can make a two-page note of the earlier judgments and your what you may call it in the next sentence coming to the Wednesday. No,
I have never, sir, prepared with your lordship's number without speaking your lordship's number.
The combination may change.
all right, good. We are ready, my friend is right. Good.
So, my lords, I am proceeding on the basis, my lords, that Devesh Sharma's judgment, my lord, which your lordships rendered on 11th of August 2023, holds the field, my lords. And that's required to be followed, my lords. And I'm saying so because the review has been discussed in the interregnum since your lordship took up the matter on the last day. The review has been discussed, Lord. But the review, sir, Lord, which typically all ratio is twofold. One is that the lordships will not tell in that particular case that for recruitment with the post of assistant teacher, particularly class 1 to class 5, diploma.
You were only concerned with 1 to 5.
Oh, yes, 1 to 5.
And you were only concerned with 1 to 5. Primary question is also split into 2.
Yes.
Primary and then
There was 8 to
yes.
that's the case. So the last
7, 8 is
yes. So diploma
or middle, higher primary or
yes. Diploma holders and mothers are the eligible candidates, which must be appointed. And these candidates, according to your lordship's interpretation of the regulation, their notification,
were not qualified.
do not qualify. That's not the one ratio. The main substantive
That's everything.
that's the substantive part of the ratio. But with greater respect, my lords, and with humility, I would like to say that there is yet another ratio in that same very judgment, my lord, which somehow, my lord, has been lost sight so far, my lord, and it was once brought to the notice of this honorable court, has been taken notice of. When your lordship says para 36 of the judgment, before my lord concluding the judgment, expressly laid down, my lord, that this holding or this enunciation of the principle will apply prospectively. What your lordship said, my lord, para 36. So it is as if not, my lord, that on 8th of April, order 2023-24, your lordships for the
What are you reading? Just show it.
para 36, my lord, if your lordship will age, SLP, my lords, that's a page.
SLP number?
That's item 8.1, that is SLP 8.10295. If your lordships will please come to page 193. 203, I'm sorry, 203. 203. So, this is para 36, I'm sorry that in the report is not filed, but in the report, 203.
How does it start?
203, where your lordships begin with saying, having made the above determination of the Lord, where we say. Having made my lord this little lords. So the second, having made the above determination, we all the same are also of the considered opinion that the state of Rajasthan was clearly in anarchy not calling the applications from BA qualified candidates, but the reasons that in the consumption and advertisement was issued by the Rajasthan government. BA candidates as eligible candidate as per statutory notification of NCDA, which was binding on the Rajasthan government, till it was declared illegal or unconstitutional.
That's the notion of law which we have said, that is the law.
That's the law, right? That's the law. The Rajasthan High Court has
As long as it is in the law books that DA is a qualification, Rajasthan government had no business not to allow DA candidates to come and apply.
That's it, right?
So they have to follow the law.
And
Now, since we have declared it to be a law,
say they are not the same position of in Chhattisgarh. Position they are not in a little converse manner. There, the DA was included by an amendment. That amendment was never questioned. The rules were framed under Article 309, the Lord Constitution, which my learned friend is making a point, that there was another set of rules under Article 309, they were questioned, they were challenged. Advertisement was issued, much prior to the lordship judgment on 11/8/2003. The selection was completed much prior to the lordship judgment, but to the most misfortune of us, the judgment came out on 11/8/2003. And at the stage of counseling, the process was halted. So the moment the judgment came on 11/8/2003, Well, our one with us, I think 2 or more 3 petitioners, who were not selected in the selection, they filed a petition before Chhattisgarh High Court at a recent bench, bringing to the notice the judgment of your lordships and said that because of the judgment, BA candidate should be excluded. I will show you where the rules were not challenged. Because of your lordship judgment in David Sharma's case, which came to be delivered on the 11th of August 2023,
Right.
a petition was filed in Chhattisgarh High Court by some BA candidates when a prayer was made that because of Devi Sharma's judgment, your lordship judgment, BA candidates who have been selected should be excluded. So now the taking note of the lordship judgment about the division bench passed in interim order said that the recruitment process where the BA candidate would be in abeyance. They not that even though the counseling was going on, the BA candidates would not be issued the appointment orders. That was the interim order. Now, we were agreed by that balance, and we came to the this honorable court. In the same ballot, the Harishankar was a petitioner, the matter came up, it was not the bench. And we pointed out this para 36 was the judgment ballot, that para 36 was brought into a present service. That was appreciated. Now, the lordships will please see about that the order which this honorable court passed at page 293. And this is how we came to the appointed ballots. Page 293. So the BA candidates were the petitions against the interim order. They had a lot before the lordships. At page 294, may I read the order ballots? In the meantime, taking into consideration that the recruitment process which was in progress is now interrupted by the interim order dated 21/8/2023, and the aspect ultimately to be considered by the High Court is with regard to the manner in which the judgment in CA number so and so, Devi Sharma judgment, passed by this court is to be construed, para 36, is to be construed at this stage interrupting the recruitment process would not be justified. Therefore, to a certain extent, we hereby stay the order dated 21/8/2023, passed by the High Court and clarified, but the recruitment process which was in progress prior to the date in the order passed by the High Court shall continue and appointments with any major order shall, however, remain. So, Lords, so 2nd July, the counseling was going on, that notification is on. So, by virtue of this order, the appointment orders were issued by the state government because the process has been completed. This order, I don't dispute this fact. Did say, and this I saw ultimately to say that all the appointments will be subject to the final outcome of the repetition.
No, this order says what?
This order says, we see the I read the paragraph once again. In the meantime, taking into consideration that the recruitment process was in progress, is now interrupted by the interim order dated 21/8/2023 of the High Court. And the aspect ultimately, this is what I respectfully emphasize, my lord, is that the view of the Honorable Court was that the aspect ultimately to be considered by the High Court is with regard to the manner in which the judgment in CA number so Devi Sharma, final judgment passed by the.
But in this judgment, there is no mention of our judgment.
So, CA number 506A, CA number 506A. 506A. That is in that. That is the first paragraph of the order. First, second, third, fourth, fifth line, Lord. They made a judgment in CA number 5068. But 506, that's the issue, not the main judgment.
I think they should.
That's the
That's the order out of which this order arose. That is few pages.
Yes, Rajesh Sharma was saying that. This, passed by this court, this court means the Lordship's court is to be concealed, to be interpreted in the light of para 36, my lords. At this stage, interrupting the recruitment process would not be justified. That means not the High Court order interrupting, excluding the Indian candidates.
It was said that at this stage it should not be, but in final outcome it would be.
It would be correct, my lord. So this is,
Some final order has been passed.
yes, now, my lords, what happens? So we all were issued, my lords, the appointment orders.
After this appointment orders were issued.
Issues. And we are working since 2023, my lord, that's from August 2023 or September 22nd. We are working, my lord, we are about 3,500 candidates, my lord. As against, my lord, the DA who have been appointed according to.
He said, listen, Singhvi said 2,800.
But I have pleaded myself in my lord at page 3,005. My lord, I have on affidavit, I have said that. But the state will clarify this, not within the current system. And my lord, 1,500 are the DA candidates who qualify, who were selected, my lord, because there is a selection. And all they have been appointed, 1,500 have been appointed. Nevertheless, my lord, there are about 12,200.
27,200
Those are still vacant, my lords. They are still vacant. So kindly visualize the situation which is obtaining in Chhattisgarh state. There are about the lack of teachers, my lords and mercy. So my lords, when we went to the High Court, the final argument as per the interim order of this honorable court, we entirely, because I was acting, therefore I can speak a lot on the bar with responsibility. I entirely argued on the basis of para 36. The submission, the Lord was this. The 2010 notification, which will not, an 18 notification, which will lodges dealt with the direction. In the background of the facts of the Rajasthan case. And the Lords, the recruiting rules which were framed in the Chhattisgarh in 2019, and that's a rule, Lord, which was under Article 309 of the Constitution. The advertisement was issued on 4/5/2003, the Lords, under the recruitment advertising. These candidates were participating, the Lords. We also participated, did not get selected, the Lord. Or someone who get not selected was lower in the merit list, the Lord. We can't help with that situation. So, as per para 36, my lord, till the rule is, my lord, is not satisfied. Because they say, the position which your lordship enunciated in my lord in para 36 of the judgment, Devesh Sharma Jail is squarely covered, my lord, in case, and we will be protected. Now, that was our submission. Somehow, my lord, we made it suspect. I want to say that the High Court has not restored its consideration to that aspect of the matter, ignoring the mandate of, my lord, the Honorable Supreme Court that this is the manner, in what manner the High Court judgment has to be conceived.
Let us see the judgment.
Yes, now if you not sure you see the judgment, my lords, it begins, but before that, my lord, could I complete the narration? I'll definitely come to the judgment, my lord. Now, 2 or 3 things, my lord, which I would like to bring to your lordship's notice. Can you see the prayer at page 219 in the Recruitment? My lord, what was the prayer? 219, which eventually has been allowed by the High Court. 219. The prayer perhaps your lordship can see in fact page 218.
They want DA to be excluded.
But what your lordships may like to notice, Lord, is this from the grounds page 218 and also the prayers. There is no challenge to the recruitment rules of the advertisement. There is no ground, Lord, and can you see the prayer at page 219, the bottom of the page.
This petition was by diploma holders.
By subsequent to your lordship's judgment on 11th August 2013, Lord, and it was indeed filed on the 14th of August 2023. With a prayer that the Honorable Court may kindly be pleased to help inclusion of DA notification dated 4/5/2013, that is advertisement. Circle wise and consequently the selection list of advertisement dated so and so may be issued after excluding DA candidates in the interest of justice, any other regime. So even like this is about the recruitment rules, not which you logically notice, that based towards, the Chhattisgarh recruitment rules, towards at page 309 rules. 309.
There will be a qualification.
Qualifications, they are not challenged. Now, the
It need not be challenged.
let me assume for a moment, but the fact situation is this, that from which state,
Sorry, but there are multiple rates. The rules are specifically challenged and the rate was filed on 30th May 23. Much before the revision.
so the nuts, this was a position, which eventually developed. So the position developed, the short question is vary. In any case, the High Court could not have going to the judgments, of the lordships in David Sharma's case, what has been holding back.
Your contention would be that the High Court has not appreciated the judgment in the right spirit.
In the right spirit, in para 36.
Like, because had the right method be applied,
Yes.
then the B.Ed candidate would have been called for it.
Called for,
They would have been selected also, and since they would have been selected, they would have been.
I'm so
And
much.
then you would have got the benefit of a subsequent review.
So I'm so much obliged, for appreciation of this. This is
This is the logic.
need of the
So
matter.
if we have understood you, then we should understand then.
For one or two things, Now, the High Court said, my lords, had only relied upon one order of your worship, the Lord, in the bench of justice and other boards and the lords. Which is at page 290, which only said, my Lord, in the context of Bihar, that please follow David Sharma. When High Court says, Lord, please follow David Sharma, it says that follow eligibility Lord's law, and also there are 36 also. So it doesn't mean, that it has to be followed in part and not followed in part, Now, it has been allowed only on the basis of this Bhagwan Krishna order, an interim order of only 1 or 2 pages or 1.5 pages.
So tell us one thing, when we were deciding that initially, on the 11th of August,
Yes, sir.
then Chhattisgarh was not there.
No, it was not part of that should now happen. The doctors were only considering the not Rajasthan case. No other state was part of it.
No, they were Bengal and they were.
Chhattisgarh was not there.
Madhya Pradesh was, actually the applicant was the Madhya Pradesh in that matter.
So, but the fact is that Chhattisgarh was not there. In fact, in 8th of April order, your lordship applied not the order, this for that it will apply prospectively across the country, so all the state that was happened only on 8th of April. But nevertheless, what
happened with that is, that was not a judgment, clarification was not given because of any misconception on law. We were very clear on law, very clear. Only thing was that, see what happens is, that these appointments, there is already a shortage of jobs in this country. With a lot of efforts, people get a job. They've got an appointment, they have been teaching, and all that happened, appointment prior to our judgment.
Right. So
There was a special equity in their favor.
Absolutely. You are the same, I respect.
Whether it is in your case or not, we are not sure.
Yes. I'll try not to persuade your lordship to say that. But there were rules, there were advertisement, there was selection, all that took place. We did not know what the law is before 11th of August 2023, so did not know it. It had concluded on 2nd July by publishing the selected list. The selection process, counseling was going on. That was the physician alerts. So that equity not entirely appreciated. The lordships have not said the lords, and I want to show one provision in the act itself, which will have some bearing. That B.Ed is not an inherent disqualification. B.Ed for teaching
It is not a disqualification.
Yes, that's what I'm saying.
But it is not a qualification.
But at the same time, I appreciate the distinction, the subtle distinction that the.
What was held was
Yes.
that B.Ed is a higher qualification.
That's correct. And the lordships in any number of judgments.
See, like
you say,
you say that driving a car is a higher qualification than cooking. How does it? They are two different.
The lords, in fact, will not have a case note, which I can submit, which lays down the proposition. just, we need to have a look at the act forward. The situation has been, and this is, the lot is contingency. Has been taken note of
Right to education.
at the parliament, right to education. And just one provision, the lot. I think, no, this is,
Even when people doing some research, I found that there was some correspondence.
yes,
Going on, this qualification
yes.
should be a 5-year course and should include primary, secondary, everything.
In fact,
So that then it is a choice open to you.
there are because the Lordship may just have a look at section 23 or for a movement purpose. This is not part of the original act itself, the Parliament Act, section 23. Qualifications for everyone. Section 23. So it says that qualification for appointment in terms of conditions of service of teachers. Any person possessing such minimum qualification, the word used is minimum, qualification as laid down by academic authority. So academic authority is NCP, with whose notification your lordship are concerned, authorized by the central government by notification shall be eligible for appointment as a teacher. This is one part. Now please see the subsection 2. Whether a state does not have adequate institutions offering courses, number 1, or training in teacher education, or teachers possessing minimum qualifications as laid down under subsection 1, not available sufficient numbers to central government may, by if it deems necessary by notification, will it reflects the minimum qualification required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification, so it can be relaxed. Provided that a teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. That's what is this course law. Provided further that every teacher appointed or in a position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of this Act No. 2016. So that's the situation has been envisaged. In fact, I did not go to the judgment, main judgment, the lordships have taken note of this situation. It all started
In 2012, and the nodal authority was NCTE. The first notification which came also in August 2008 somewhere says, takes into consideration many of the states which may not be having the available UP, I'm always for UP, both of us.
Yes.
And that what happened that every district had a training center which was called DITE, District Education Training Institute. And in that institute, at that time there was a basic shikshak function and all that. 100, 200,000 selected, get a training there for 1 year or 2 years, you come out and then train teacher of elementary school. Right? So these trainings are not available.
But in Chhattisgarh from 2019 it is available.
So that reason what that said is, if the state makes a request, then for 5 years, B.Ed will be considered qualified citizen. So it was relaxed to 5 years.
In fact,
Another 1 year, another 2 years, how can it go?
in fact, the background in David Sharma's case is that the commissioner of the central schools, Indian Vidyalaya, he took up the matter in
How it started.
the central government that look, this Vidyalayas are having an acute shortage of these state teachers. It's a miserable condition, and the central government therefore at the appropriate level, namely at the ministry, took note of this fact and issued this the amendment into the qualification saying that B.Ed would also be eligible. B.Ed eligible, but B.Ed would also be eligible so that this contingency will not be as a reason on account of non-ability scattered and that is the provision, but somehow
But have you made diploma also eligible?
Yes, eligible, that's in the principle.
Secondary, high secondary.
Yes,
May be eligible for secondary and high secondary.
yes, can you see a
No, you have not. You have not.
Each of that.
But which school? Between this class 8.
So we are concerned with
Elementary.
elementary, so
It's elementary.
we are concerned with class 8 only.
From 1 to 5 it's elementary. from 6, 7, 8 is senior regiment.
I mean, so what's the middle? You got to so much of knowledge.
No, मैं middle ही कहते थे. Middle pass हूँ, मैं middle pass. 8 pass is a middle.
Those days were not, my grandfather was a middle pass, then he was heading such highest.
Yes, the village, if you are a middle pass,
That was a great money.
And sometimes if you could do metric correctly, and even if you don't pass, you are metric fail.
that's it.
So, that was quite a mistake on the. So, this is how the situation is. Now, if you worship with me, sir, note, it's not a lengthy note, my lord, but I try to
This one.
articulate my submission, the Lord, in the best possible manner as a.
Shankar,
Yes, Harishankar. This one, my lord. And may I not slowly read this for a place before you work with. There are certain subtle distinctions from the facts. The batch of cases arising in Chhattisgarh and from the new judgment in WPs filed by DA candidates in substantive petitions arising the full set of facts which are negative bearing. Proceeding on the basis, that's very important that judgment in David Sharma is the final word as regards eligibility as not to pay the laws. The ratio of the main judgment in David Sharma 11/8/2023 expressly stated judgment is prospective, that is para 36. This part of the law has been unfortunately not brought to notice in earlier proceedings except one in the order of the Honorable Supreme Court dated 29/8/2023, which I have read, my lords. The Honorable Supreme Court expressly observed in the order dated 29/8/2023 that the High Court is required to consider ultimately the manner in which David Sharma judgment is to be construed. In the Detriment judgment, the 11th High Court has not complied with the Honorable Supreme Court's order. That's my submission. The net effect of the improved judgment is to quash the recruitment process concluded by the state government vis-a-vis PA candidates. Unlike other states, the recruitment was held under the Recruitment Rules 2019 and the advertisement was issued thereunder. The validity of the values was not challenged. This is subject to correction because Mr. Shankar says that the lords, I did not have the copy of other applications. In regards Kaushik case, at least I can make a statement. In Devesh Sharma, the Honorable Supreme Court merely rejected the prescription of NCTA and not the rules made by the governor under proviso to Article 309 of the Constitution. The petitioners are protected under the applicability ratio of Devesh Sharma in main judgment read with the clarification order 8/4/2024, that's para 36. While passing the order which is made applicable all over, petitioners who had acquired vested rights were not heard. We were not heard, the lords at least. Both when the main judgment was passed and also when the Lord 8 order was passed. They are not party to the order. The advertisement why state of Chhattisgarh has been quashed only by the High Court now, while the new judgment dated 2nd April 2024, without considering the binding ratio of David Sharma, that's 36, it operates from the date of judgment. It would be illegal and unjust. It should be unjust word. I'm sorry, it's a typo to allow the new judgment to unsettle this state of affairs. The private respondents are not prejudiced by the retention of the petitioners. All those who qualified in selection have been appointed, and those who did not have, no, I do not like this pause here for a moment, because I don't think he stated on behalf of the others, but I have taken clear instructions from the set of my petitioner to my representative. Of course, it's not a fight between us and the state. It's a fight between the and the edge. Correct, Lords? Now we have run out of the options, Lords, and as matter of it will come as the last submission, but I'm making it right away.
So why is it that it is not a fight between you and the state?
No, but the state is saying that it is also taking the perspective, they're saying it's also
The
problem.
reason is that the entire focus, sorry to say, that even after the Right to Education Act, the focus is on employment rather than on quality of education.
That's maybe a situation, but not that really more about
The problem. State is,
and employment also,
you
but
have to give employment, not at the cost of.
so that's in that context, what I'm saying, the Lord is this, and it may be only as there are prejudice to my rights, a lot of submissions. In the merit is about what are we fighting for? They think that if could be agreement for up in the they will get with higher seniority, better chances of it in future. Before come from that state, I can tell you what is the conditions which are prevailing socio-economic conditions. It is predominantly a tribal state for us. And government is such a not
It's a poor state.
No, I'm not saying
It's a rich state.
So that's
It's a
a,
rich state, people very.
that's a paradox. That's a
Rich in mines and minerals, it's a rich state.
rich, that's a rich in resources, that's a paradox. But Millard's,
It's a rich state with poor people.
that's what I'm.
That's very unfortunate to very so.
They're very poor people. So Millard's employment is such a big thing, Millard, these days, such a big thing, Millard, that I'm Millard is very hard, and with a meeting hard, I'm ready to make this concession so that Millard, employment opportunity once this Millard only in a lifetime. It may not come to me, Millard, again, Millard, in my lifetime. Millard, therefore, and if we are not so much inherently disqualified, we have also undergone that we are ready to undertake the bridge course which will also be stipulated in Act and Appeal Order such the bridge course, which is being run by the state in Chhattisgarh state. Our employment will be protected. If they have to get a higher position, let them if that is their good fortune, wish them good luck. Wish them all the best. So para 7. Apart from this, the exam conducted by the state for appointment of assistant teachers that questions pertaining to. Now this is very important, Millards. Not that we are completely foreign or alien to this requirement of the qualification or the specialized training. Had questions pertaining to technology and questions relating to elementary education. Secondly, the DET certificate, which is mandated by the rules law, reading teachers eligibility test certificate. The teacher eligibility exam for class 1 to 5 had questions of technology and elementary education, and the DET candidates have taken the exam and passed the merit.
Hey, you're right.
They have achieved.
Here you are right to some extent. I agree with you.
They are totally not.
No. Because I've seen the TET papers. I've seen TET papers here, UP, in Assam, and also the central government and the state government. They are very good questions which are set up in.
And we have taken that, right?
Yeah. Right, pedagogy is
Yes.
way. If it's not available like that, how will the teacher? You are trying to say that, all right, I have not done this.
I may not have.
But I have passed the exam, so I am capable of doing it.
Sir, so I am not a complete
I am a good teacher.
good teacher. I can become a good teacher. I can become a good teacher. I can take care of the interests of the teachers in the primary schools. While the petitions are fully protected under now, I come to your lordship's order of clarification, dated 8th of April 2024, which I read. Now, while the petitions are fully protected under the main substantive part of the clarification order 8th April 2023, and the underlying idea of prospective, 24, and the underlying idea of prospective overruling laws and equity as much as the two clauses of the exclusion of the clause stipulated in the order do not apply vis-a-vis the petitioner. Subject to final outcome, that is what Ramesh, your lordship dismissed the Mr. Gopal Narayan argued this animal recently to change the order around where the one roof is made. If the subject to the outcome is a condition imposed by petitions filed by them, then the lordship has said that would not qualify in our favor. Subject to final outcome, clause stated in the order must have been imposed in the cases which might have been instituted by them. The idea to change the condition has been dismissed by the Honorable Court for the reasons matters require serious consideration. My submission is now twofold, if I can very briefly, I rely on para 36 of the lordship's judgment. That prior to 2003, much water had flown under the bridge. The recruitment process issuing the appointment orders had been included under the element to be struck down below at least 111 in 2003 when your lordships laid down the law below. Even that is cited in the applicable in 41, but that became the law only on 11 in 2003. Second July is the of the selection list. Number one. Secondly, what we can do. Your lordship's clarification order of 8th of April 2023, which I would say further clarification in terms of including para 36 of the main judgment laws, the two conditions do not apply to us because this institution that subject to outcome of the final outcome of the petition was not imposed not in any petition filed by us. It was imposed not on the petition filed by them. The third is not, I met the Lordship's that completely. If some way the law could be found with the help of the state government to protect an environment, but the grateful to Lordship's laws. And we can move, we will undertake which was additionally as has been permitted by your Lordship's order.
Which course as we understand?
No, Chhattisgarh, I can show you what this is. As some of them are already started to say that I have already undertaken the bridge course. I can give the details of those things. But I went to the Chhattisgarh website a lot, and the government's order and the guidelines for the bridge course is available. I think this is 2019, not all have been set up, so it is available in Chhattisgarh. I can't say about the other states, not the commission may be different. We are ready to undertake that, every condition we will comply with, but please, see that I appreciate that not at fault for us. We face the search on for work that get qualified. We have not submitted our application.
That nobody speaks to.
That's all I have to say. This is the matter of the council. Today, your lordships are hearing only for admission in the Lord. And I hope that they got hearing it. Your lordships, but for the present,
Not the whole day, the same combination.
I'm grateful for the day of that school.
Yes, Mr. Madam.
What the
However, in this case,
You're also from the same batch.
correct. I am just going to add. The whole trust underlying your lordship's clarification of the law, that a person who has already got appointment, an appointment is so scarce, we should find a way to protect his appointment. Here, the only distinction between that situation and my situation is that physically my appointment letter came on 29th September 23, and your lordship's judgment is 11th August 23, and that is their star argument which they say every time, that this is after death. And this is after detriment because the guillotine has fallen on 11th August. so not according to that.
Judgment will be guillotine for what?
Start okay. So Lord, just kindly consider this is earlier. Entire process of selection is early. Happened, and our counseling had happened first. We would have got the appointment before 11th August. So, Lord, therefore, my first submission is everything happens earlier. Only because the counseling which started on 14th July, but first the higher classes were counseled and came to the lower classes.
Actually, your selection and appointment is prior to the death.
So my submission is, my appointment really actually is on 2nd July 2023 when the final merit list had come. It was a foregone conclusion that unless my document is, there is some fraud, unless my mark sheet is wrong, I have did something wrong, I am to be appointed. The ministerial act of offering the letter only occurred on 29/9/2020. So really, my lord, this is a case where actually 2nd July 2023 should be the date when I should be considered to have my job. And if that is the basis, then my lord, I am within the time limit prescribed by your lordships, even in the clarification judgment, because my appointment is here. Original writ petition was not filed by me, they had filed the writ. That is one thing which your lordship needs to keep in mind, my lord, apart from what my learned friend is asking. The second, the Chhattisgarh rules which were enforced on 5th September 2019, 5th March 2019, clearly held that beer is illegal. Following those rules, the advertisements comes in May 23, also holding beer is illegal. Therefore, we participate in the process of selection. The first writ petition is filed on 30th May 2023, challenging the rules. Actually, they will have to challenge the rules because notification had already been quashed by the Rajasthan High Court, and therefore it was pending here before your lordship. So they relied on the Rajasthan High Court judgment to say that notification already been seen. These rules should also be struck down. There was no interim order granted in that writ. The second writ petition is filed on 14 August 23 after your lordship. It is in that writ petition that they secure an interim order on 21st August saying to don't allow them to participate in the selection. The High Court said. Then that came here, which my learned friend Mr. Srivastava read, and your lordship said, allow them to participate in the process of selection, consider it as the final stage. Second point which I am making is that in the state of Chhattisgarh, the rules actually permitted to be here. And the rule is struck down for the first time in this impute judgment now. So therefore, till this impute judgment came, my statutory rule authorized me or made me eligible to participate in the process. That is the second factor which your lordship may keep in mind. Taking into account the last paragraph of your lordship's mini judgment, Mr. Srivastava read, that so long the rule is there, you can't stop it. You have to allow them to participate. So I have actually participated in terms of my rule. But who I would remain eligible, even if there is a law which is declared by the court saying the notification is bad. That's what your lordship said in the way. And then when Bihar came here, that also said beyond the notification, rest Bihar is not a party, let it be decided there. So my second point is, my first point being that 2nd July is the crucial date which your lordship would see. Counselling was only choice of station, etc. Appointment letter is a ministerial act which may have happened later. Second point is under the rules, I remain eligible and therefore I should be considered. The third issue which I am making is of equity.
Second July, what happens?
So my first point is that the final merit list is announced on 2023. That is in my writ petition, it attached as an extra P14 and paid.
It will take it.
Yes, yes.
The rest is ministerial.
Yes, I say counseling was not process of selection. Counseling. So as they say,
Not even God on that.
if my art had no statues, he would have been my uncle. So that also is there. So
That's only we can say. And madam, that's all.
But my third, virtually we are only now left this Chhattisgarh last. There are 27,200 posts lying vacant. The solicitor, he would bear this out. But
the notifications are different.
correct. So 27,200 posts are lying vacant. And we are about 3,500 and all the VADs can be accommodated. And still there are thousands of vacancies left where we can be continued. And we have been working a lot for the last 1 year. And Lord, I am instructed yesterday and told that some of us have left jobs in private and other institutions to join this appointment. We have taken loans. We have some have got married on this basis.
September.
Correct.
And then you join.
Correct.
The High Court order comes on.
The High Court order is 2nd April 2024.
And then you're not teaching anymore.
No, we are actually continuing even up to today.
How?
Because this matter is pending, the state is also in appeal. And the state, if he lets 3,000 teachers go, their schools will suffer immensely. So therefore, they are not.
Schools will be closed.
Yes, it will suffer immensely. 27,000 otherwise are vacant. Another 3,000 if they discharge, then they will be left in a situation where they will be in dire straits.
Most of the appointments here are in Bastar district and Sarguja district, which are the entirely tribal districts. And also not conferences that they are also excellent. That
Ramesh, I can tell you what is that people are not willing to go to Bastar, it's very hard. But to get some person to go and serve in Bastar. The situation is so bad, you lots of read in the newspapers every day. They don't go there.
So, therefore, Lord, in fact, even when your Lordship was hearing the clarification, your Lordship was always of the opinion that if somebody has got a job, then we will make it prospective so that his job is protected. When the IA filed by them got rejected, your Lordship said that we wanted to see if somebody gets a job. And not having got this job, these people, God alone knows whether they will ever get a job again in their life or not. Therefore, life will change. And I can understand if we were competing, somebody was being ousted from people who are fighting with us. Nothing of this kind is going to happen. Everybody will be accommodated. Correct. So, everybody will be accommodated. That select list is already there. That's not going to change now. They will again advertise. And experience has shown that there are not sufficient candidates available most of the time.
If you are excluded, then the diploma order will come in.
Yes, but they are already in. They can still come in.
More
The select list.
the waiting list requires only 25%. Not otherwise. And they are not the ones who are coming here, not in the rate. That I am in the waiting list or I am not.
And how many qualified candidates are actually available in Chhattisgarh? That may also be a very relevant. That is also going to be a very relevant statistic for your Lordships to ultimately opine which way your Lordship is going to finally take a view. So this is.
Yes.
You will see this at page 649, that clarification order in my petition. A, at page 649. Yes. Item 8, page 649. Just kindly see page 649. This only 2 paragraphs. This, your lordship.
What are you reading? What is this?
This is that clarification which your lordship said, protect those people who are working. Just kindly see this, what your lordships have stated here. And I am trying to invoke the same principle there for you. Six 49. The panel on top of the page, since my lord has not yet seen it. 649. Now an application has been taken out. This also explains the application. Just for your lordships. Page 649. The fresh panel on the page.
The present petition stands alone.
No, page 649. Does it say now an application? Yes, yes, yes. Now an application has been taken out by the state of Madhya Pradesh. Taking it as an application for clarification. Applicant seeks for us to hold that the judgment ought to have prospective of application only. Though framed as an application for clarification, it is in the nature of a review petition only. Though the applicant is the state of the said dispute is subject matter of large number of litigations in various states. We are raised in some high courts, the matters are pending. Before us, 2 sets of parties are there. One set wants retention of the said judgment in its present form. But in such a case, it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their BA. It is submitted, they had entered their employment following a legitimate course as per notification issued by the respective appointing authorities, which had not stipulated BA to be the only requisite qualification. Now, having considered these factors, and particularly the contention of the BA applicants, that they had entered their employment as per qualification criteria specified by the appointing authority, equity should go in favor of retention of their employment. Then these are the 2 technical objections your lordships have dealt with. Kindly come to page 651. In the given middle of the page, in the given facts, we find that the question as to whether the judgment would be prospective or not was not stated as in judgment. 23. Ordinarily, a judgment acts retrospectively unless it is specifically stated to be otherwise. Moreover, this matter has been heard on several occasions, and the points of the respective parties have been taken note of by us. As it appears that a large number of candidates with B.Ed degree had already been, now this is the court speaking, now this is not argument, this is your lordship's verdict. As it appears that a large number of candidates with B.Ed degrees had already been appointed on the basis of eligibility criteria specified by the education authorities, we do not think it to be equitable to effect their removal. I am drawing great strength from this line. Page 651, the last tab I'm reading. As it appears that a large number of candidates with B.Ed degrees have already been appointed on the basis of eligibility criteria specified by the educational authority, we do not think it equitable to effect their removal. That's what your lordships had observed also orally. That somebody who has got a job now, let us lean in favor of that person and try to.
We are still prepared to lean in their favor.
Because the part against me I must read, because therefore otherwise I cannot get anywhere.
That's very good.
Yes. Think it equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on verse 23 shall prospective opposition, but prospective for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might have been instituted by them, and such candidates were in regular appointment without any disqualification and were appointed in pursuance of a notice of advertisement where we had stipulated to be a valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear, this benefit is only for candidates who were prior to the date of our judgment was delivered on 11 August 23. Mere selection of such candidates or their participation in the process will not entitle them for the benefit under our present order. The last 4-5 lines are the ones which put us out of the benefit of this order. I am trying to overcome that by saying, please take 2nd July 23, which is the final select list. The rest is only counseling, Lord. Your Lordship knows, even in medical news.
Even if you take 2nd July, then what is it? It is not your appointment order.
No, it is my selection.
We have protected, we have said selection is not a part of this.
But it is virtually, my appointment stands finalized on that date, is the point I am trying to make.
There are too many steps within the cup and the lip.
But the issue is, this counseling is different from anybody. It's just like you are given an appointment subject to character and antecedent verification. That happens later and then you go and there is a joining. So therefore, that's the submission.
So,
Do not read anything.
Ultimately, Lord, the point is we are only invoking your Lordship's input.
That's what verification of this order also.
So the other side did not.
clarification of a clarification of a clarification.
The other side, as my friend is rightly saying, that application was rejected by your.
Yeah, they did not sort it about it. But I want to show 3 things, and I made 2-3 submissions. Subject to Lordship training. The first one, if you Lordship see kindly, the SLP, which is the first item listed today, because I think that is the reference would be easier for me in your Lordship also. Item A, kindly just.
Naveen Kumar.
Please, Naveen Kumar, I am requesting your Lordship to have the advertisement first, my Lord, which was issued on at page 448 in volume 2. I have to have this back to the Union of India. Volume 2. Volume 2, Naveen Kumar versus Union of India.
Page number
448.
is part of the advertisement.
I am reading, the full advertisement is there.
Government of India Ministry of Education.
No. 448 is annexure P12, which is Directorate of Public Instruction, Chhattisgarh, detailed advertisement. It could be Naveen Kumar versus Union of India.
Right, Naveen Kumar versus Union of India.
This is additional documents which my friends have filed last night, some 1200 pages. 448. Sorry, that paper book is not to you.
Additional document, part of education.
It's volume 2. It's actually volume 2. It's volume 2, Vivad, actually. SLP volume 2. Annexure P12.
Right.
My Lord, have it, Vivad?
Detailed advertisement.
Yes, Vivad. May I just show these 2-3 things from here? Pursuant to so and so, department a brief advertisement was issued on the docket inviting online applications to fill vacant posts of district cadre. Essential education age limit and other are as follows. Now, if your Lordship will kindly mark below, assistant teacher e-cadre in education, and there are total of 9 places, which is only within the Shikshak division and the Bastar division. And on the next page, assistant teacher tribal, T is a tribal card, non-resident. These places are a total of 13, are also within these 2 divisions. The total number of vacancies, your Lordship will see the second last column on 449 is 793, and on 450 for the T cadre, tribal cadre, it was 5492. 5492 at 450. Your lordship will see the second last column. So this makes it a total of approximately 6,000 vacancies. Now we have kindly just see the note below the chart at page 450. The post of assistant teacher T cadre contain include vacant post.
Where?
At 450, below the chart, just where the chart gets completed, there is a note. The post of assistant teachers T cadre.
T cadre would be?
The tribal cadre.
Tribal cadre.
Yes. Contain include the vacant post during the direct recruitment made in the year 2019. So 2019, even all the posts did not get filled. So therefore, this is being mentioned. That so what happens is because people are not willing to go to the tribal cadre, vacancies still existed. That is why.
Not going. You have to be a tribal in order to fill that post.
No, not the area.
It's a tribal area.
Tribal area.
Because to the area.
Yes, sir. I mentioned Bastar and Sarguja division. All these places are.
Like something like a hill cadre.
Please, much obliged, very obliged for that. So, and now your lordship will kindly just permit me to show at page number. The Detriment is as per the rules, and the qualification is at 457, and thereafter, my lord. Now allow me to show one more thing, my lord, and that is the rules, my lord, issued by the state government, 2019, which is one of this SLP at page number, my lord, 125, 125 of 125.
But these vacancies which you are saying,
Yes.
27,000 and all.
Yes.
Are they only for primary schools?
So kindly just, yes, sir, kindly come to.
Or they also include 6, 7 and 8 also?
No, sir, kindly come to page 654 in this very second volume. Page 654. I'm sorry, just the second volume which your lordship had just now. Kindly come to page 654. This is second February 2024 regarding or vacant subject is regarding the appointment of the vacant. And then kindly come to the, since it is possible to make a proposed appointment in the financial year 24-25 as per information, the four possible expenses are mentioned. And over the page, assistant teacher, 3,000. Assistant teacher, 19,000. And at page 657, top. Information of vacant posts as available in December.
This is assistant teacher of the entire elementary cadre.
Assistant teacher, are of two cadre. Assistant 1 to 5 and assistant teacher 5 to 8.
So they include 1 to 5 only or 1 to 8 to 5?
That's not true. 1 to 5. My lord,
This is not clear.
but they are what they are. I am getting instruction in.
How you get it? And
That-
second is, see, even if it is
The last column, just kindly see below the last column at 657. Information of vacant posts of assistant teacher. I don't
those who take 6, 7, 8, they are also called assistants.
That is 1 to 5 because this assistant teacher. 6 to 8 is not teacher.
You call them teachers.
Teachers.
So when you say assistant teacher, by implication, we 1 to 5.
1 to 5.
And 9 to 12 is lecturers.
9 to 12 is
Lecturers. Lecturers in the school.
lecturer.
If not here it is mentioned as professor.
UP is class 12 and with the BA qualification. So it's good.
Lord, here it is mentioned not as professor. Kindly see the second column. Professor, teacher and assistant teacher. That's 657.
Professor would be a person who would be pedagogue, who's training. Then you don't teach. There are professors. You call them professor when they become trainer. When teachers become trainer, they are professors. Normal school.
So, but all that I'm trying to
Normal school.
assistant teacher total will not 657. At 658, your lordship will find is 27,200. 658 at the end of the chart. Total is 27,200. This is a notice dated 2nd February 2024, proposing for making appointment. This is a proposal from the Public Education Directorate to the Secretary Chhattisgarh government, and this is the annexure to this letter. And the 659 shows the total sanctions, strength allot, and post vacant. Just kind. We also see
That's it, 27,200.
this firstly, please. And this 659, if you lordship just see 659 also. Scheduled information of sanctioned working and vacant posts.
Right.
So assistant teacher science laboratory total 34,075. But total sanctioned posts are 88,000, working post 54,000, vacant post 34,000. So I am only showing this for the purpose of appropriate lordship's observation just now. That about the vacancy position, this is the government letter, which I have annexed here, dated 2nd February 2024. Now, I just wanted to show the rule for a moment, which is at page 125 in volume 1. We are placing 5th March.
Yes.
It's a gazette which we have registered. 5th March 2019. In exercise of the powers conferred by the proviso to Article 309, the Governor of Chhattisgarh hereby makes the following rules relating to recruitment to the Chhattisgarh School Education Service, Educational and Administrative Cadre. And it's called, the number 1. These rules may be called Chhattisgarh School Education Service, Educational and Administrative Cadre, Recruitment and Promotion Rules both. And it has come into force on the date of its publication. And the service is mentioned. And if your lordship see at page 130, Roman 2 at the top.
The Chhattisgarh School Education Service
Yes.
Covers class 1 to class 12.
Yes, sir. The service is defined. If your lordship just see at Q 126, services, Chhattisgarh School Education Service, Educational and Administrative Cadre. That's what it says. And the constitution of service is mentioned in section 4. Now, if I may, section 8 at page 127 says conditions of eligibility for direct recruitment. And in this plot at 130, Roman 2 at the top, educational qualification, the candidate must possess the educational qualification and experience. Sorry,
Yes.
130 at the top plot, Roman 2. The candidate must possess the educational qualification and experience as prescribed for the service, as shown in column 5 of schedule 3 for preliminary education. The prescribed qualification will be applicable as per the provisions of right to free and the right.
What is in schedule 3, column 5?
Yes, now that column your lordship will find.
That is NCT. NCT will fix the.
Yes, at page 145.
Right to education.
No. Right to free, NCT has its own act. There is a National Council of Technical Education Act. There is a National Council for Technical Education Act.
Right, that was a body formed under a different act.
Yes.
But under the Right to Education Act, what is to be the qualification will be set up by a nodal agency
Yes.
to be notified by the government.
Yes, central government.
That nodal agency was NCT.
Yes,
And then NCT was
which notification I have annexed at page 119?
2010 that notification.
2010. No, it is at page number 111, 31st March 2010.
You see section 23 of
Yes,
that
23 is what not 23 says that, no?
23 subsection 1 says
Please.
any person possessing
Any
such
person-
minimum qualification as laid down by an academic authority
Authority. Authorized by the central government by notification shall be eligible for appointment as a teacher. So they were not, NCT was appointed as the academic authority in 2010. And one not that notification which your lordship was of dated 28/6/18
all under this provision.
was under this provision. Now, and that was an amendment made in 2018.
Yes.
Yes. Now, the rules here were framed in 2019. The 2019. And here, at page number, the schedule 3, which is mentioned here, at page 130, small Roman 2, or at page number 145 in the schedule. 145. No, not here, in the paper. I was reading, I was placing not the Chhattisgarh rules. So in those rules, there is a mention that for education.
They are talking about column L1 of the rules.
Yes.
What is that?
That is at page 145.
That will not be contrary to this.
No.
145.
145 says schedule 3 and it says below that see rule 8. Rule 8 as I not submitted earlier, it is conditions of eligibility for direct recruitment. So therefore, not assistant teacher at the top, minimum age, maximum age. Now at minimum educational technical qualification as per annexure 1:1. And then name of the members of the selection committee are mentioned. Now this 1:1 annexure is at page number 152.
Which column you are reading?
I am reading the first one at 145. 145, first one assistant teacher.
Assistant teacher.
Yes.
And
the
the
fifth-
1:1.
Yes, annexure 1:1 is at page 152.
What does it show?
It only says, it says at the top, name of service, minimum age, maximum age, minimum educational qualification, name of the members of the selection committee. The selection committee composition is mentioned.
No, but the minimum qualification.
There is, as per annexure 1:1 it says. So there is an annexure 1:1 at page 152. But really permitted to close the mic, Lord, I think, because that's why I'm closing it. I know it.
Then closing, the right word was wrong.
Yes, Lord. It was reverberating as well.
No, zero confidence.
I am aware. But I
You don't need a mic.
I don't need this. I am very grateful for that. Page 152 now.
वैसे ही बहुत बुरा तो
Page 152 now, Lordship may see. Yeah, lecture 1:1. So 1 and then 1 is for assistant teacher. So senior secondary or its equivalent, senior or secondary elementary, etc. Lord, kindly come just above B. Graduation with at least 50% mark and BA qualification. Graduate from the institute and from NCT. That's important. Shall page 152, the top that starts with assistant teacher, and Lordship may come to the sixth one. Graduation with at least 50% mark and BA qualification. Graduate from institution recognized from NCT shall also be eligible for appointment as teacher for classes 1 to 5, provided he undergoes after appointment an NCT recognized 6-month special program in education. So this is how under these rules the advertisement came, and under the advertisement we participated, and that's how and I have shown the number of my lord, Devesh. I want to show two lines. I just 165, 565. I want to just rely on one observation which your lordships have reiterated here in this judgment, not in this volume, that lordship will take the volume 2. The judgment was start 520 and at 565 above paragraph 37. I want to read those 3 lines. May I place it? What the Rajasthan High Court had stated above is a settled legal position. In a recent legal judgment, the judgment of State of Manipur, this position, now not mark the that a statute which is made by a competent legislature is valid if it is declared unconstitutional by a court of law has been reiterated. Here it has been declared, we have struck down this rule on 2/4/2024 in our case.
Till then it was valid.
Till then it was valid.
By that time your
My appointment is anything. I am only
You're a good lawyer, Mr. Ranjit. Well, you're. No, you're.
Consequently, the appeals are dismissed and the judgment of the Rajasthan High Court is upheld. The notification dated 28/16 is hereby quashed and set that all pending applications stand disposed of in the light of that order. This is a decree to be executed. So what was quashed was the notification. Now, I say, make one more argument subject to your lordship pleasure. The lordship knows not entry 11 of list 2 was education till the 42nd amendment.
Yeah.
It was a state subject.
Something
Then in the concurrent list SB 25, it became in list 3. Now state has, in my respectful submission, to prescribe a qualification for the purpose of its appointment.
Yes, yes.
It has a right. The state did it. But whether it did it because of this notification or otherwise, it can't be gone into because it is a legislation under Article 309. Now, so therefore, it exists till it is quashed. It is quashed when, Milord? 2nd April 2024. So therefore, I am making a respectful submission, Milord, that as of the date, the operative portion of this judgment did not say that the Chhattisgarh judgment, the rule is in effect. What your lordships have decided in this, that the notification issued by NCTE could not be made or not to have been made and have been made because of certain correspondence between the government, the Kendriya Vidyalaya and the central government, etc. And the reasoning below is that elementary education will require somebody who is well versed in elementary education and not otherwise, and therefore the lordship said that the BEd is not the right qualification. So so therefore what the lordship did was quash that notification. Nothing more to learn. May I place it? Volume 1, page 56, para 39. For the foregoing reason, the writ petition deserves to be allowed by declaring the prescription of qualification of BEd as eligible qualification for the post of assistant teacher as illegal and without jurisdiction, which deserve to be quashed and are hereby quashed. Consequently, the advertisement dated 4/5 to the extent it permitted the candidate having the qualification of BEd to participate in the process of selection for the post of assistant teacher is also declared illegal and quashed. The state government is directed to rearrange the selection list in accordance with the provisions of Rule 2009 2019, I, excluding the candidate, participated in the selection process having qualification of BA. This is the operative portion of the improved judgment law of the High Court. So I am only saying, Lord, I reiterating, and my friend has made a statement that even if I go down and they go up, Lord, really speaking, in these tribal divisions, teachers are required, a fresh recruitment process and vacancies will be to the detriment of everyone. I'm much obliged for the indulgence.
Yes.
Please.
अभी हो गया
बहुत सारे
तो भी
तो यहाँ पे दो लफ्ज़
decide among yourself who let us first.
I can't jump.
I want to point out
Batting order is still.
there are legal issues to be taken. I'm not going to argue legal. I don't want to argue legal issues. They are also very broadly legal issues. They are always substantive. They are not. Let's not get into that.
See, most
Go into the factual.
you all have argued till now.
That's why I'm dealing much of that. I'm not even.
You know it.
Broadly, I know. Broadly. That's why I said I had got a list of some legal issues. I don't want to argue. I'm not getting it.
You'll
It's a larger picture. I'm sorry.
be arguing on equity.
On facts and equity, very quickly. Please kindly keep the holistic larger picture. I'm not in the blame game. I don't want to be the blame game because what I have, I want to protect. I'm not going to get into my blame. For whatever reason, there is a delayed appointment there. The formal sense. Everything about selection and otherwise the substance is done before the day. Now the result is, I'm told on the figure for us about 2,800 collectively. 3,500. I was going to 3,500. The posts are more than that.
Suppose some
27,200, including 500 less, 500 more, exactly. Now, whereas today, maybe I can't make this argument in the High Court. Maybe the High Court doesn't have the power. But certainly I can and should make it the apex court. Today, whereas a technical strict application of the rule doesn't help anybody. Shut down guillotine, out you go.
you are also subjugated guillotine.
Everyone? No, it's
Guillotine is a very strong word.
I see. I did not hear Mr. Patwari at that time because
I have already expressed my apology for.
No apology. This is what the matters. Cut off day.
No. That was the French judgment. We are not going there. The Supreme Court.
He also said Qatar. Don't just violate it.
He is a very good child.
I never did that sound.
All right.
Let's see.
What is that? Nakara has established that all cut-offs are they are in that sense they are guilty of the line. Now, what is having that my solution is this was we also were eligible, most of us, in all three categories of different classes. 1 to 5 is one class, 6 to 8 is another class, 10 is another class. See the practical level, they are not people who are going to litigate and all. They are practically, they chose this, right or wrong. Now if they are there, I wonder what is this absolute strict thing? I can argue that your lordships have a judgment one way, your lordship has Devesh, your lordship has the other judgment, etc., etc. That is not the point. Today, in by your lordship beneficial use of 141, 142. Forgetting everything else. Yes. Your lordship keep not from very
As far as legal is concerned, which is 6, 7. Disqualified for
Chhattisgarh, DL is also quite great. For 6 to 8,
no.
DLP is also.
Right from the very beginning, correct me if I am wrong,
Yes.
B8 is a qualification for 6, 7 and 8, no problem there. So, are you arguing that we may be considered for that?
No. I am saying at the time when this happened, I had correct. That's what I'm saying. I made the wrong part of it comes retrospectively now. Perhaps what High Court can't do, the lordship can issue to. The lordship can exercise the beneficial power. my lordship has that's the problem.
The only problem is, we don't know how many tailoring we'll have to do after this. Because that only job we will be doing of tailoring.
No, I checked that. No, this is exactly what I checked out specifically.
You can't make a commitment for entire India.
No, I can. In this case, I can. Fortunately, my lord is absolutely right. The floodgates argument is a strong deterrent to court, as it should be. In medical cases, your lordship has a floodgates argument. The deterrent should be there. In this case, I expect everybody is getting a very mind. This state is the only state. Or that is a tragedy. Because that's it. It would be in my favor.
This state is the only state.
Chhattisgarh is the only state. Chhattisgarh is the only one. It's another process. But you know, that's the third aspect. Equity aspect number one, there are enough cases. Equity aspect number two, I made a choice. That choice I cannot now reclaim. Because I have a fork in the road that time. I chose this fork. Today also said this fork is wrong. I have no option of going down the other fork. Number two. Equity number three. All my processes were over before 11th of August, etc. Only the formal thing happened after 11. And this happens to be possibly the only state which did this. Equity number four. Well, it is not because of any fault of mine. If the state took 4 weeks extra after 11th August, it's not my fault. I'm not complicit. There's not a case where I contributed to something and did something or had an indication or a stay. So, I may actually punish from a fault of mine. These four equities, I submit, become a powerful combination for your lordship to exercise my fifth point, which is your lordship's beneficial power, which the Supreme Court can and does always exercise. It is not bound by any law. Your lordship doesn't have to be strict about it. There are no cut-out dates to stand in the way. And sixthly, this is the only state. So the floodgates argument, which is rightly an important deterrent to your lordship, rightly an important deterrent to your lordship, would not be a deterrent. Because my lord is right, so many people come, we can't control it. But here it's a virtually finite figure of 3,500 and 27,000.
Why is it 27,000 and
Post.
27,200 is the post.
And 3,500 is this batch. Our categories for this. So these five are my only submissions. I have notes on the paras of Ramcharan, Devesh. I think it's a futile effort. Those things have been dealt with. In fact, I'm not here to point out something was not cited, something was not incorporated, something was wrong. Then we have also taken out case for my student. So on that, it's a reality itself and also beneficial power.
So if you say Imperium, then we can easily hold something for an Imperium, which actually gives you benefit.
Therefore, I am not being tempted by any such thing that fed to me at the beginning. I am not tempted to this. I started by saying that. Therefore, that's why I really need to oblige your accommodation.
Yes, Mr. Hegel. Please.
I adopt everything that has been said. I'll be very brief. My brief point is this. Your lordships, in the original Detriment Sharma, itself said that till it is struck down, period continues. That was in Rajasthan. That position in Detriment Sharma was available before the High Court. The High Court, the question before the High Court was how do you construe prospective? Or is it prospective? Is the Detriment Sharma to be applicable prospectively? Because your lordship's subsequent order of 8th of April, even after the High Court judgment, the High Court did not have the limitations on prospective. The High Court could have very well. The High Court judgment was 2-4, 2nd April, and your lordship's judgment is of 8th of April. 8th of April. The clarification order is of 8th.
Clarification order is subsequent.
Yes, subsequent. 2nd of April. So if the High Court had gone on the footage that till such time that the itself is struck out, not by implication, not by anything else, then my lords, we would not have necessarily fallen about even of your lordship's clarification order. So therefore, my lords, if your lordships now turns to how the High Court approached the problem, because the High Court has at page 51 of that same page 51, para 33 onwards. Question mark analysis and only very few factors. Page 51, possibly in the first book, in the A. And your lordship goes by the fact analysis. What would be the effect of law is para 33, that's what is set down. Para 34 is that B.Ed is not the qualification for at the primary level. That is how they understand your lordship's judgment in Devesh Sharma, and at the end of para 34, they say the prayer as sought in the writ petition declaring the notification of the NCT as the ultra-virus illegal has already been decided by the Supreme Court in Devesh Sharma, therefore it need not be again declared as ultra. Then, my lords, this is the para 35 is the real part of it. Rule 83 of the rules prescribes the qualification for teachers in the appointment, which speaks of the applicability of the prescription of the qualification and RT Act as mutatis mutandis in the rules of 2019. The state has committed illegality by permitting the candidates having the qualification in the selection process initiated by the appointment, since the said qualification does not exist in the statute book of the RT Act after its quashment by the Rajasthan High Court by its judgment. So, my lords, the Chhattisgarh High Court proceeds on the footage that because Rajasthan had quashed it, and that issue was still pending before your lordships. Therefore, from that date onwards, it becomes illegal. The rules of Chhattisgarh have been developed or by this honorable court. And your lordships made it clear in paragraph 36 of the Devesh Sharma that still Devesh Sharma
I appear in 8.3, but I just want to point out one fact. Lord, in Devesh Sharma, in first paper for I see at page 554, I appear in the 8.3, Lord. We are 48 petitioners. And Lord, I adopt all the other arguments, only one on that I just wanted to point out to my lords. At page 554 in the first petition only, so that my lord don't have to jump in the petition. Devesh Sharma's last three lines, what weighed in my lords by considering the 554, Lord, volume 2. Lord, the judgment is starting at page 520 at 554, last three lines. Just want to show what weighed in my lords. Rajasthan case was being decided. Last three lines, page 554, volume 2. Hello, just 554. This is part of the Devesh Sharma judgment.
Wow.
554, last three lines. This, besides the fact, last page 554, this, besides the fact that there is presently no such bridge course available, at least there was none till the disposal of petition by the Rajasthan High Court. Lord,
No, Rajasthan High Court says that.
yes, Lord, on the factual position, Lord, in
Chhattisgarh
there is, Lord, we have just passed on, there is, and the rule is specifically prescribed that a VA qualified candidate would be entitled to appointment
6 months.
with 6 months. So therefore, there is a factual difference from the Rajasthan High Court as far as Chhattisgarh is concerned. Lord,
therefore, my lord, when considering the
Which goes in Chhattisgarh.
and that is the prescription in the rule. Rule does not simply say that make candidates eligible. It says that you have to undergo the code. So this difference in factual situation, therefore, must be looked into by considering the factual situation and equity when are being decided. And the curriculum of Briscoe is also prescribed, that also we have passed on. Any concern? That's all. So Briscoe, but therefore, when my lord is considering this case, please keep this in mind. And our humble submission is that at least permit us to continue in terms of that clarification of the subject to those two conditions being relaxed in our case. Because those two conditions come in our way, that those two conditions may be that it has to be appointment, not the selection, and there should not be any the appointment should not be subject to any outcome of this. So if those two conditions are relaxed,
Thank you, Mr. Tiwari. Now let's. Wait, please. I mean, there is still.
There are 7 petitions.
Your floor?
Chhattisgarh state. As it is, if you apply the previous judgment and subsequent clarificatory judgment, so far as relief is concerned, I don't think any relief can be granted in this matter. Because the entire, so far as relief is concerned, and the previous judgment, we have clarified that while the appointment is already completed, only such people can be protected. So if you apply that one as it is, I don't think these people have any case as it is yet to observe. But however, state has issued the notification.
And also for those petitioners who have been appointed?
We are not meeting.
You're for the state.
It's our recruitment process. Our.
Because then after all, it's your law.
Yes, our. Therefore. Yes. As it is, if you apply the relief part of those two judgments, first judgment and clarificatory judgment, I don't think all these parties can get any relief in particular matter except exercising the relief of equity. Now, as a state, independent of the question of law, once having appointed all these persons, they want to use some kind of, apply some kind of relief, the equity in the particular facts circumstances of the case, that is the stand of the state government. For that purpose, with regard to the table, what I pointed out is.
So you tell us something, if you can just.
Yes.
See, like Mr. Singhvi was arguing, that I had to make a choice.
Yes.
1 to 5 or 6 to 8.
Yes.
I said 1 to 5. Although he's also qualified for 6 to 8.
That's right.
So can you change the choice midway?
No, we are not, I'm not on that. I'm not, absolutely I'm not on
So
that.
you're saying equity, this equity you can do.
Yeah, if equity can be appointed, this one can be exercised, only this one that can be considered, that is one part of it. But I am on a particular position of law which I would like to point out.
Oh.
Yes, only small point, which because we are not parties to all those proceedings. That is that, as it is, only 2 points, beyond that I do not want to go into that. Now, one is the Ramcharan judgment, which was not placed before some court when the Devesh Sharma judgment was considered, that was not under consideration.
What is Ramcharan?
Ramcharan case, that is, the very notification had come up for consideration. That is in 2021-15 SCC 401.
We considered actually.
Yes, subsequently by RP that was considered. Now the second part is, can we take the recruitment rules here in this particular case? They are on the top. Yes. Yes. Page number 92. Yes. Any paper, any recruitment rules is part of all the paper.
Paper 125. 125, 125.
Yes. Amended at page number 92.
You can take up your case.
Yes, yes.
8.54 you are.
Yes.
128.
125 is Ravi Kumar, but the state of Chhattisgarh has it on a different right.
Which page is yours?
It's a 92, it starts from 92. It does not matter only on the, to show the proposition that these are the rules framed under Article 309.
Let me know, no problem.
309 rules have been framed. Now, if you go to Article 309, conditions of service will have to be prescribed only by the governor of the particular state for any kind of state services.
Yes.
These fall under the services under the state. For services under the state, the governor in a sense of power under Article 309, he can frame the rules and prescribe the conditions of service. The eligibility also is a part of conditions of service. And also, that is in 1994, 4 SCC 390.
What is the point?
Yes, now if the government of a particular power under Article 309 had prescribed a particular eligibility criteria, then unless that rule is found to be wrong or ultra-wise, then whatever the appointments or the exercise undertaken under that particular rule should remain. That is the first thing. Now, can you see here the rule has been set down now. But
Recruitment made by Mr. Ranjit Kumar.
Mr. Ranjit Kumar.
that was very different. I was specifically pointing out with reference to this particular Detriment and also Article 309.
Whatever has been done before the striking of the rules.
So,
That will be very.
it is not only for that point, because of Article 309.
You pick up a jail member,
Yeah.
old British,
Yeah.
wearing a Gandhi cap is a crime in jail. But it is still in the book. You need to set aside, declare it. What is the point? By implication, it's wrong, there is no use. Khatam.
But otherwise,
It may not be a very good example, but broadly, you got it what it said.
yeah, I understood.
Just because it's in the books,
Unless it is examined in the context of conditions for service falling under Article 309, the eligibility what can be prescribed is only under Article 309. So far as services is concerned, it falls under the services, not an education.
no, because you're right and wrong.
Yeah.
Education, including private education, after the 42nd Amendment comes in component lists.
Absolutely.
Now, once it comes in the component list, both the center and the state can make law and executive power also goes.
Absolutely.
Now, what has happened is, if the center has put up a qualification,
Yeah.
let us say diploma,
Yeah.
state cannot say it is something else.
So that's a different. Now here it comes under services. The eligibility for recruitment, that was under services under the law. Services under the state, that can be done only under 309.
You're right.
Yes, 309. Now under Article 309, this is the eligibility prescribed by the state by prescribing under the rules. Then unless those rules are going to be totally wrong for various reasons, maybe unconstitutional or for some other reasons.
Services, then whole lot of principles would come in, the rule of written substance would come in, the rule of implied stacking, there are so many things.
Yes.
On law, Mr. Natarajan, you are nowhere. दूर तक नहीं उठे. It's only bachao.
No, whichever is one point, because they are basically they have freedom and have support as the recruitment for appointing agency.
That means,
Yes, that's your one part of it.
because I mean, मतलब सोचेंगे उससे. अभी तक नजर नहीं आ रहा, रोशनी नजर नहीं आ रही. I mean, you're not getting light.
This getting close right because of this particular situation where the High Court has struck down this particular rule later. And till such a time, whatever the appointment that has been made, and that has been vested in the light of two more facts. As of now, since there are about 27,000 vacancies in generally, and in this particular recruitment process, about 984 vacancies are there, that is on facts, that's on the instruction. If that is so, it can be molded in respect of this particular recruitment process. In the light of the fact that the rule has been struck down, the rule had notified the particular eligibility criteria, and when that has been followed, until that is struck down, the appointment which has been made, that has to be accepted and that has to be protected. PC section 1994 4 SCC 391 45.
Yeah.
1994 volume 4 SCC 391.
Please go to page number 396. Hold on, the principal and putting it.
Eligibility is part of service condition.
Yes. Please go to page number 396. Raising the trust and deed. 396, page number 396. The government has been, at page number 396. The government has been given power under proviso to Article 309 of the Constitution, subject to any law legislation, to make rules regulating the recruitment, which includes prescription of qualification for appointment to an office or the post under the state. So it is an office under the state, services under the state. So under 309, particular rules are available and have been made. And that has not been actually, with the due respect, that was not the subject matter of a debate or the, which has been considered when the deviation had fallen for consideration before the Islamic court. That's one part. And secondly, here in this particular case, the High Court says that because the Supreme Islamic Court has, in Dev Sharma's case, said that that is a particular eligibility criteria, this rule has to fall. This aspect of the Article 309 and the validity of this rule and the efficacy, that was not a subject matter at all. If you can only apply this particular principle to the facts of this particular case and leave the other issues open and can be protected, there is one thing I can say in this particular case, people can exercise. So we are not heard, we are not parties to the earlier clarificatory order, the first order, and all those things. We are
As a state of Chhattisgarh,
yes.
you are more concerned with giving jobs to untrained, unqualified.
Definitely not. The standard has to be.
You are lesser concerned with the quality of education.
Definitely, we are concerned about the quality of education. For that, by imposing some condition, they have to undergo some kind of this one or something and exercise. Then you look at it, beyond that, I do not want to go. These are all equal. There is which has to be only in their favor, not in my favor. I have nothing to say about the equity part.
You have filed a separate SLP.
Yes.
Exactly is the relief you are giving.
Relief SLP.
You want the High Court judgment to be set aside.
That's all. Then what is? This is one angle from angle.
In other words, you are saying the judgment dated 11 AM is set aside.
What? This is the larger or broader perspective, and within which you can more benefit accordingly. Beyond that, I do not want to, as a state, I can't say it.
We'll hear you after lunch. अब हो गया ना यहाँ से खत्म हो गया।
जो स्टेट आया है, can't tell you.
Come on.